The limitations, and can everyone hear? I hear myself getting louder when I lean forward, but I don't feel I need to. Can you hear me if I don't lean forward? Okay. Okay. All right. So that's the main differences between legislative and quasi-judicial. Both require notice and an opportunity to be heard. In quasi-judicial, you're acting as a judge. Here's a big one. Ex parte communications. Nicole, I know you know what that is. Does anyone else know for certain, if I were to ask you what is an ex parte communication, you could define that for me, you could give me examples. Is there anyone that's not sure they know exactly what that is? Okay. Ex parte is basically a communication with one party. Ex parte means essentially one party. You're communicating with, say, the applicant, but the public can't see that communication. Or a concerned citizen comes to you and says, I need you to hear about my concerns about this application, which you're going to hear next week. That's an ex parte communication. It's a communication with one party. It's outside of the process. It's outside of the public hearing, and therefore it's outside the view of the other party. For a quasi-judicial hearing, you should always look at it as there's at least two parties. Usually there's only two. There's the applicant who's in front of you and making a request. They're entitled to due process. They're entitled to have their application fairly considered and heard based on the approval criteria, but the public is also entitled to due process. They're entitled to notice, they're entitled to an opportunity to speak their concerns or their support, whatever the case may be for an application, but it is really important that neither side have information that the other side does not. That the public can't come to you and convince you to vote no on an application that you haven't heard yet, and information the applicant hasn't even had a chance to address because they don't know it was said. So an ex parte communication is a very bad thing in a land use context, and you would imagine from a judicial context as well. You don't want your judge talking to the adverse party while you're out in the lobby. That doesn't go very well. And it doesn't go very well for a reason.
Wendy, what are the ramifications of having that ex parte conversation? What can happen to a planning commissioner?
The worst ramification is probably that the entire process could be invalidated, whether it's just the recommendation of the Planning Commission or that recommendation makes it to the Board of County Commissioners. If the communication exists and it's considered significant enough, it could invalidate the decisions all the way up the line. So there's probably not going to be personal liability for an ex parte communication, but it can invalidate the entirety of the process, which is a pretty negative thing to have happen. There are ways to deal with an ex parte communication. So I used to joke when I would talk to commissioners, I would say, just don't go to the grocery store or church, because someone's going to approach you and they're going to talk to you about this thing that's coming up that you're going to hear. But when that happens, there are strategies to deal with it. So someone comes up to talk to you, they happen to know you're a planning commissioner, and you don't have a clue why they're coming up to talk to you. That's not uncommon. And it takes about 2 sentences and you realize, uh-oh, they're talking to me about this application that I just received that I think we're hearing next week on the Planning Commission. So you can and should excuse yourself in some way from at least that part of the conversation. You can still talk to people, you can still go to church and the grocery store, but don't talk about the applications when you're out in these social environments. There will be people that try and get your attention and try and get your support, whatever that means to them, before you ever make it to this room and start what is considered to be the due process. So it is important not to have them. If you do have one that's inadvertent, you're talking to someone, it's a polite conversation, and all of a sudden they just unload on you 2 or 3 sentences of things you wish you hadn't just heard about an application that you're about to hear. There are ways to deal with that, and the single biggest way to deal with it, there's 2 really ways to deal with it. The best way to deal with that is disclosure. So when a hearing starts and before anything else gets said, you put on the record, this is where I was, this is what I was doing, and this person came up to me, and I don't care if it's the applicant, I don't care if it's the public. You disclose what happened. I was minding my own business and I was accosted, whatever the case may be, but you disclose the nature of the communication. And then the attorney, if there's one in the room, and if there's not, you can do this yourself. You can say, look, I am not tainted by that. I am not swayed by that. I am ready here, willing and able to consider this on the merits and on the record presented to me, but I felt it was important enough to disclose that it happened just in case either party, either side wanted to address the issue. So one way and one common way to deal with an ex parte communication is it was inadvertent and it's fully disclosed. It's no longer a secret where you have information that was shared with you by only one side. Another way to deal with it is if the communication's bad enough and it does taint or could taint your ability to make a fair decision and recommendation, you can recuse yourself. There's really no other grounds that I've ever discovered that make sense or that have come up in the legal things I've read about an ex parte communication. They were either not so significant that you can't continue to be fair, so you disclose, or it was pretty significant and you even pause and think, I'm not sure knowing what I know right now I can be fair. So that would be a recusal. I'll just take a brief sidestep on what does recusal mean, what does recusal look like. Recusal means you're not going to weigh in at all. You're not going to sway the opinion of the board at all or the commission at all. You're going to actually physically leave. So you're going to announce that I'm going to recuse myself. You may or may not be able to announce the reasons why. It might depend on those facts. And certainly I would be available to talk through that if you had some questions about it, if this comes up. But you would actually just say, I'm going to recuse myself from this, or maybe you don't show up that night, but people know in advance that you're not able to hear this for some reason. And then you don't influence the board because you're not here. You're not asking questions. Your questions aren't directing the rest of the deliberations or conversation. You're just not part of the process because for whatever reason, you couldn't fairly be part of the process. Yes, sir.
So I'm new. A lot I don't know. So when does an application become a legal entity? So in other words, when does an application become an application at which you certainly want to avoid any conversation regarding that?
Yep, I can answer that, but it's not going to be as black and white as you'd like. So a little bit of that is determined by each entity. So Elbert County can and should, and if I have my way, they will draw a bright line where everybody knows when the ex parte rules kick in. But let me explain. So it might be that an applicant comes in for a pre-submittal meeting. They want to talk about their plans. They want to talk about what they're thinking about doing. They want to talk to Jennifer and her staff to figure out, okay, what pitfalls am I facing here? What do the regs say? What might be allowed? And that person comes in, they have a pre-submittal meeting. Now, we don't know if that person's ever going to submit an application. It might be that what they're proposing and what they're talking to planning staff about is potentially very viable, supportable, supported by the regs. It's in the right area. It checks a lot of boxes. And that person may well go forward and formally file an application and then start through the process that leads to planning commission hearings and board of county commissioner hearings. That may happen, but we don't know because there are applicants that are also dissuaded. They come in, they have plans, and they realize, oh no, there are some real pitfalls here that I was not aware of. I don't think I'm willing to take this on for this location, for this use. I'm not going to apply at all. So should you be able to talk to that person? That's where I say it depends on the entity where you're having your hearings. So I can tell you Douglas County's rule was a bright line. It was when an application is filed, you should not have any communications regarding that application. But it was a bright line. It didn't start at pre-submittal. It didn't start at anything other than an application is fully and formally on file. And that was true for county commissioners and it was true for planning commissioners alike. Now that said, it's a clear bright line. When an application is filed, that is the point of no return. The rules kick in no later than that moment in time, because at that point there's an application that is heading for and is already part of the quasi-judicial process. Before that, though, it is gray. So the rule and the bright line for the entity may be it's the time of application, but that doesn't mean that ex parte communications can't happen that would still sway your opinion or affect your ability to be fair. So if a communication happens and then it becomes an application and it's heading towards your desk to hear, there may still be a reason to disclose that conversation at the relevant time. And you're going to kind of get a feel for when that is, if it was a communication with you with some specific thoughts on the application. but that was also later reduced to writing and submitted, and every planning commissioner had that same information because it was formally submitted and it's in the packets, and the applicant could respond to it and everything else, and there's really nothing different from what you were told, well, maybe it's not so important you worry about disclosing that. It's already in the hearing, it's in the packet, it can be fully addressed. But there can be other types of information too, those stray pieces of information where you're pretty sure you know something and you're not sure everyone else does. Well, then we need to consider whether that has to be disclosed, even though it was told to you before there was an application on file or before you were a planning commissioner. You're out there in the world, you're hearing what you're hearing, you're communicating with everybody. You weren't a planning commissioner yet, but all of a sudden there's a vacancy and you are. Disclosure may be appropriate in those situations, and then again, recusal could be appropriate in those situations depending on the nature of the communications. Related to ex parte communications, but a little bit different, is predetermination. And
I did. I had a question related to this on the other end. When does your duty to ex parte communications end?
Good question, really good question. It depends. I actually had this conversation today. Right. But it depends on facts, not anything different from that. So when a judge hears a case, when are they going to be able to talk to the media, for example? Have these communications with either one of the parties or someone who was never a party, but these unique conversations about the file. My advice on that is don't ever do it, and I'll explain all this in a second. But when does your duty end? Arguably when your job ends and this matter cannot come before you again, you could safely communicate, hear from people, have communications, because your job as a judge has already ended. But there's also always the possibility of a remand. And so at the Planning Commission, this, whatever this is going to go from you, presumably, to the Board of County Commissioners. It's pretty rare that files die in between those two, but it does happen. But it's probably going to the Board of County Commissioners, so it's still very much in process. And so I would say that anyone in the process should avoid any of these pitfalls of due process for at least as long as the application is still live. So you certainly wouldn't want to communicate with a county commissioner after you've made your recommendation, because they still have to hear it. That is a communication that they shouldn't be having. If there's the possibility that the county commissioners are going to hear this and remand it back to you for further deliberations and further recommendation, maybe new facts are offered at the hearing that you didn't have privy to, that can happen too. So in general, I say just don't. Until the application is done, just don't have communications about the application outside the public process. But I can't tell you there's a case or two or three cases that clearly define that. I just know the risks.
And when you say done, you don't necessarily mean only the BOCC vote, right? Because if the BOCC denies an application and it's appealed in another setting, then you still have the case ongoing.
Right, yeah, timeframes matter. And so what is done, I think, is the question, and something I wanted to hit on anyway. So let's say you make your best recommendation to the Board of County Commissioners. The Board of County Commissioners makes their best decision on the same application. Is that application done? They've made their decision. If it was required to be in writing, they put it in writing on that day. Is that decision done? The answer is no. Technically, it's not. There is a 28-day period for most land use applications that it can be appealed to the district court. It's called a Rule 106 appeal, and it's for abuse of discretion. So all of these issues I'm talking to you about always come up in these Rule 106 actions. But there's a 28-day period following that final decision of the Board of County Commissioners where this thing isn't decided yet and it may still be appealed. So I asked commissioners, I've begged commissioners not to make any comments to anyone during these 28-day periods at all, because they aren't final yet, and anything they say can be easily quoted and will be quoted in a Rule 106 action. Well, they said on the record that they based their decision on X, but
Can be used against them in the court of law.
yes,
Right?
and will be, I assure you. So I beg and plead for 28 days at least that nothing be said, done. There's common media requests for county commissioners that make big decisions. And again, I beg them not to do anything for at least until day 29. But then I add, I wouldn't talk to the media then. Not all of your roles are acting as a judge. Not all of your roles are quasi-judicial. But when do you ever see a judge go before the media to defend their decision? Tough, easy, you just don't. It's not a role that lends itself to these open public dialogues about this is why I did what I did. It's just kind of a different role. So there's never a time it's gonna look right, but after 28 days, so after day 29, it's probably not gonna impact the application or the proceedings, probably. Now, if you say something catastrophic at day 29, and they did file their appeal before day 28, I'm still gonna have to defend it. Well, they said it was about this, but now they're admitting those issues come up too. They're not common, but they do. But there's never a good time to defend publicly your decision. Here is where you defend publicly your decision. Here is where you address the approval criteria and why you are voting or moving to vote the way you do. The approval criteria are everything. This is where you deliberate. This is where the record and the facts are developed. This is where you make whatever statement you need to make about why you're doing what you're doing. I encourage you not to do it anywhere else, at any time, even after day 29. But after day 29, it's relatively safe, as relative goes.
So I got a question that is based upon not ex parte, but experience as a resident of the county. And without stating specifically, I raised a question during the recent Excel application. And I asked them, for part of their application, they made a representation to us of what was presented to the community during their community meetings, to the citizens of the county. And I saw a discrepancy, and I called them out on it, specifically when they were talking about the various slides, information that they were presenting, and there was a couple slides that all of us, saw when we went to those community meetings that wasn't there. So I first asked them, do you feel this is a fair representation of what you presented to the community and the county residents, during those meetings? And they said yes. And now I called them out on, well, you were missing this. And frankly, they came up with a really lame excuse. But that wasn't based upon an ex parte, but it was based upon my experience. How does that hold water?
Well, it depends. You actually raised several issues at once without maybe recognizing it. So the Excel application was more complicated than some because there was two sets of approval criteria that applied at the same time. You had your SUR application and you had your 1041 application, and those approval criteria are very different. So to the extent that the answers to the questions affected the approval criteria in either of those two environments, they're fine questions to ask. Okay. So if the answers to those questions help you determine, yes, they meet this specific 1041 criteria, or no, they don't meet this 1041 criteria, then it's always a legitimate question. But if you can't in your mind articulate why it's connected to something that is your approval criteria, you shouldn't be asking the question. It doesn't serve the process at all, and it might actually taint the process if it looks like there's bias. So let me get into a couple other things. They're similar to ex parte but different. Bias and predetermination. So if you are next door to an applicant and it's going to affect you tremendously, and by affect you, I mean positive or negative. It's going to make you millions of dollars, or it's going to make you feel like you're going bankrupt because you lost your piece of heaven in the property that you own. If you have bias and cannot be fair, that is something that doesn't just get disclosed. That's something that results in recusal. So if you cannot be fair, if you know you cannot be fair, that is almost always financial in the case law. You will have a direct financial impact, not gain or loss. It's anything, direct financial impact. And that applies to your immediate family members as well. If they live right next door to your son or daughter, and it's going to absolutely impact them, and you know that, that would be something where you would be biased, unless you don't love your kids, and that's odd. It happens.
In a lot of cases, when somebody's been noticed as part of the application, we have been approached and talked to about whether at that point you need to recuse yourself. And so you need to be asking yourself the question, am I going to be fair and balanced in this conversation, or should I recuse myself and step out? Now, the one case that we had where the commissioner recused himself, he literally sat down in the audience, which is probably not exactly the smartest move.
Well, yeah, you've heard what I recommend for recusal, you leave. If you're physically present with your colleagues, some of which presumably you get along with, maybe all of which, I hope it's true, all of which you get along with, you are influencing them by being in the room. Leave. If you're recusing yourself because you can't be fair and you think it taints the process, physically remove yourself so it doesn't remain a shadow over the process. So one other thing I was about to hit on, and I think there might be another question I haven't answered yet, but predetermination. If you have heard enough about an application, there's not a darn thing anyone could tell you to change your mind. You are a solid yes or you are a solid no, and the testimony's not going to matter. You have predetermined the application and you cannot be fair. So if you cannot consider the record that is presented to you, the information provided in the staff packets and from the applicant and from the public, if you cannot consider only that in your deliberations, you have an issue, whether that's bias, whether that's predetermination. It doesn't really hit directly on ex parte communications, but the whole process is about a fair recommendation. And if you can't do that for whatever reason, I would say, talk to me, find a time to talk to me, and we'll figure out what, if anything, we do about it. But also consider recusal might be the only option for you in a situation like that. Yes, sir.
I mean, I see this as a real gray area. So what determines being objective and fair if it does impact you, or, I mean, let's just say this can impact you, your property value one way or the other, but you still have a responsibility as a planning commissioner to do your job and to do it, you know, in a correct way. And you know, in a case like that, I think it only makes sense that we should have a conversation with you individually and basically get your guidance, you know, in terms of whether we can be fair and objective. But I mean, just give me kind of a sense of what is being fair and objective if you are a commissioner that wants to abide by the rules and the ethics that are expected of us.
There's an easy answer to that, but I recognize it's hard in application. So the easy answer to that is, are you capable of voting yes or no on the application? Are you capable of hearing the evidence that's presented again in this room, from the public, from the applicant, from the staff, from the packets, and getting to a yes or getting to a no? When you go in that hearing, is it possible that you can get to either result and that you're willing to do that based solely on the record? If the answer is yes, there's a good chance you can hear that case. Now, when you've got bias because of, you describe a financial interest, whether it's you or an immediate family member, maybe the bias is something that really can't be overcome. You can say that you'd be fair, but you're pretty sure you know what you're going to do. Well, all of a sudden we're talking about, okay, can you really be fair? But I can tell you how I handle that on the record. It's a conversation much like this. Okay, so this application would have an immediate impact on you. It's 250 yards from your front door, and it's going to impact, you believe, your property values. Probably it's going to be a negative impact, or you're not so exercised about it. But you have said that this directly affects you. And you've said you are skeptical about this application and this use, and you're not sure you could approve it. I'm just going to ask you on the record, can you be fair? Can you consider what the applicant presents to you and the information they present, and are you capable of voting for this project despite the impact you think it might have on you? If the answer to that is anything other than yes, I'm going to tell you can't hear the case. So again, answer is easy, facts are hard, but the answer is, can you be fair? Are you capable of getting to a fair result based on the record?
Back to something that you said earlier, it might have been in response to Nicole's question, and I didn't quite hear it. Are you saying that we as planning commissioners cannot have conversations with one another or with a county commissioner unless it's part of a public hearing?
If you are in a quasi-judicial process, your deliberations about that application should be limited to where you're sitting right now. That's where the quasi-judicial process takes place. So if you are meeting with staff, meeting with people about the application, with the intent of evaluating the application, yes, I would say avoid those conversations. I'm not saying don't read your packets. I'm not saying don't prepare with the information you're given. You should do all those things. But having those side conversations that can amount to, intended or not, deliberations, those absolutely should be avoided.
Okay.
I've got a couple. The issue with the criteria. Should we, because it sounds like that is important, although in our regulations it doesn't say that we have to follow the criteria, just consider it in our deliberations. But am I right to assume that the criteria doesn't come into the decision process until we've determined that the application conforms with the zoning regulations first?
Yeah, no, I don't really agree with that statement. When an application comes to you, it's been vetted by county staff that it's an application, that it meets enough of the criteria to make it to a hearing. I don't think the county has asked you to make those background determinations whether the application should be in front of you or not. So when you get an application, it's about the approval criteria. It's about what have they applied for, what have they committed to, what do they bring to the table, what are the surrounding land uses, does this application meet those criteria? That is a quasi-judicial process.
Okay,
The other things are not.
let me jump in then. Yes, in a perfect world, I agree with what you're saying. But we have had issues, we do have issues where we're receiving packets where we don't have all the required documents for the zoning regulations. There's missing information in them. There's wrong information in them. And I know for myself, that's one thing that I concentrate on. And that's something we need to address, because we're not at the point, in my opinion, where we can just get an application and only need to consider the criteria. And and I was hoping we would have time to talk about that, because that issue is part of one of tonight's hearings. But the criteria that we do have doesn't have any underpinnings to it. So the harmony, there's nothing to help in the regulations or guidance to help us determine what does that mean. It's squishy. It is subjective. It's not objective. And that's a problem, because I think what I might think is in harmony, Nicole might not agree with. And if it can't be objective, then how do you apply that evenly to all of your applicants that come in?
Yeah, I'll do my best to address that, but I can tell you something you said a minute ago I need to back up and address. Your criteria, like most criteria in a land use regulation, says you must consider the following approval criteria. Consider doesn't mean I can follow them or not. In a land use context and a legal context, it means those are now the binding criteria. These are the factors you must consider in voting for this application. And I can tell you the law in Colorado is if it meets all approval criteria, you must vote to approve. If in your determination it meets all criteria, that is required to be voted yes. And the reason for that is if you were to do otherwise, it makes the criteria completely arbitrary. And the flip side is also true. If it fails to meet even one of the approval criteria, so you consider one of the approval criteria, no matter how hard you try, you just cannot determine that that is met, you must vote no. That is the law in Colorado, played out in the case law. You have approval criteria, you must consider them. They're either all met, resulting in a positive vote, or one or more of them is not met, resulting in a negative vote.
Not to take this away from you, Diana, but one of the things that we've considered in the past is it's a hard and fast rule, and staff, not harping on staff, but staff has presented this is incompatibility or in harmony, this is compatible, this is, et cetera. They've included their opinion on each one of these. And so when we judge, we're judging that case and whether that case is made or not. And our opinion in this case may not agree with what staff has said, and therefore we can use that as our ruling criteria to say yay or nay.
And if I could just add on to that, there are times when, and again, not piling on with staff, but as they go through the approval criteria, which does shall be considered mean the same thing as will? Is that language
For
the
purposes of
same?
approval criteria for a land use case that's quasi-judicial, yes.
Okay.
If you have approval criteria, those are mandatory, regardless of the precursor, whether that's consider or.
Okay. So when we get to the staff presenting and they go through the approval criteria, there have been times where staff has just repeated exactly what the criteria is without providing any substantiating information. And again, we have no guidance in the zoning that helps us to determine what's in harmony or what is compatible, or are all services going to be met. We don't always get that information, and that makes it arbitrary to me.
Okay, well, I don't necessarily agree with you because there's context to not just the zoning, but to the application in front of you. So if you are in a 5-acre lot subdivision, single-family residences, and the person next door wants to rezone to commercial and put in a McDonald's, you can exercise reasonable judgment to say, okay, is this application, is this request in harmony and compatible with the surrounding community? And that's really the language that's in the code. And while you're right, it is possible that someone could, absolutely, if you've got 5-acre residential lots, you've got kids and they like McDonald's, you can stretch it, but most people can look at that and say, no, these are not compatible uses. A commercial use with high traffic in an otherwise fairly rural area is not compatible with 5-acre lots, rural uses, residences, that sort of thing. It's context. So the language, it's not anything, it's do I like this? That's completely arbitrary because there's no standard whatsoever. Harmony says connecting these two things, do they harmonize? Do they fit together? Do they match somewhat? Compatibility is the same thing. So there's a context for use of those terms that doesn't make it arbitrary. It doesn't make it anything you want it to be. It's not whether you like it or not, it's can you determine that this application in this neighborhood is harmonious between the two?
I think that's something we really, as a planning commission,
I would like to have some more specificity because in counties like Douglas County, it's really clear, okay, this area is zoned for this type of development. This area is not zoned for that. For example, here in Elbert County, when you have mostly, 5 or 10 acre, like minimum size area lots, but then a high density development is approved and considered to be harmonious and compatible, it makes you question, okay, so where exactly are we getting our definitions when in the past, the decision makers have said that this is harmonious and compatible, but you have high density development next to, the smallest size lots, maybe 5-acre lots. So it would be helpful to have a better idea. Otherwise, it really does just become my decision, like what is my perspective of what is harmonious and compatible? Would another high density development like
But
5
you're
miles down
you're
the
making
road?
the great point, Nicole. You're making the foundation that in your judgment, which is what we do, this doesn't fit.
However, I guess the point that I'm making is that there's also possibilities here to be maybe a little bit more clear in the zoning regulations if there is a desire of the BOCC and our Planning Commission, right? Those of us who are here to talk about the legislative side of things, if we want to have more clarity or definition versus each individual's own perception of that, because it has led to things that don't appear to be quite that harmonious.
Fair enough.
My favorite example is cricket pitches in the middle of 30, 40 acre farm community. It was something that I voted against because cricket games in the middle of a farm community doesn't seem to fit and doesn't seem to be harmonious, does not seem to be compatible. And yet when I voted no, I was almost kicked downstairs because we could have been sued because it was potentially considered racist. And race doesn't have any consideration in what we're doing here. We're talking about judging land use.
Let me offer this, because I think it's pretty important to the overall discussion right now. Staff's going to make their best recommendation with their expertise and with their experience with an application, whether criteria has been met or not. Jennifer and I might work together and work on the way that's worded in staff's opinion. This criteria is met if you accept X, Y, and Z. But bottom line is, I don't care how it's worded, it's a recommendation. You are the fact finder for anything that comes before the PC as an application in a quasi-judicial process. And if you disagree with that recommendation because you're looking at the facts, you're looking at the application, and you don't feel you can reach that same conclusion, that's your recommendation. You've answered your own question. I don't find that this is harmonious or compatible because I heard this, and this, but I don't believe that to be true. I don't think that's as persuasive as what I heard over here. So make your recommendation based on your determination on whether those terms are met in the context of that hearing and that application and that specific evidence.
Yep, absolutely. The other piece of the puzzle that I wanted to throw in here, and to Nicole's point, because it was valid, we had a Board of County Commissioners that were pushing a growth at all costs philosophy. And growth is good. Growing and developing is good. Growth and development with a plan and approach and an architecture is something that we should be focused on, and we're not. We need to get there. But, you know, to the criteria, we're back to how do we judge, how do we determine, and it becomes, you know, what is the evidence that we see in front of us, and how do we apply that evidence? And if the evidence is complete enough for us to make the decision, that's the key. Is it complete enough? Well, then we can make the decision.
Well, and also on top of that, if it's complete enough or close to complete enough, but we do see a simple fix, we can always make the recommendation for approval with a stipulation. And I think also, you know, on the behalf of some of these people who have spent a very, very, very long time in the application process, going back and forth, you know, in dealing with staff and any of the outside agencies that they have to either get answers from, you know, to just completely deny an application when you know full well, just tweak it before the BOCC meeting and get her done and be able to, you know, allow them to move forward, you know, based upon that. You know, I would hate to, you know, stop someone in a process that is 99% there, you know, only to say, well, sorry, you didn't fix this one little teeny tiny thing. You know, that's unfair to them.
Now, I want to make sure you have about a 5-minute break because you're going to start a fairly long hearing. So we got about 4 more minutes. There's a couple things I want to hit, but go ahead.
And I know we're short on time. I really want to talk about the memo that CDS sent out on Thursday.
We're going to have to put a pin in that. I'm not prepared to talk about that tonight.
That's going to, but how is that going to impact the land use hearing tonight where we don't get all the documents that are required?
I'm not sure I agree with that conclusion, but my answer doesn't change. You're going to have an application in front of you, and they're going to present the facts as they believe them to be. You're going to have a staff report in front of you. They're going to present the facts as they understand them to be. You're going to have the current approval criteria, whatever that may be, and you've got your judgment with the facts presented, with the record presented to you. Does this meet the approval criteria?
Well, what if we're not getting the
If you
full
cannot
record?
answer that because you feel you're missing information, then that is your recommendation. I cannot conclude these are met, and I cannot recommend this because,
Okay.
and that's fine. I don't necessarily agree with the way you get there, but I don't need to agree. You need to apply the approval criteria to the facts and make your best recommendation. Couple other things real quick. Don't develop your own record. You come to the table with whatever knowledge you come to the table with, but you're not expected to go out and do your own research either on Mr. Google or out in the community. You're not expected to drive by and take pictures and do all those things. That is not a decision on the record presented to you. If you need more information and you need some sort of photo simulation or something, ask for it. Ask the applicant, ask staff. Don't do your own investigation. Judges don't investigate their own cases, and you're not supposed to either. That is not basing a decision on the record. That's the exact same impact as an ex parte communication. It's information available only to you that's not part of the record.
That's a great thing to say, because in the past, they've asked us to, you know, if you feel comfortable driving out this property, go see where this application is gonna be. Road conditions are often brought up, and if you haven't driven that road, go drive that road. Things like that, which actually could sway you in terms of yay or nay. And you're right, it basically sits outside the bounds of what a normal investigation would look like.
And there's a big difference if someone tells you, hey, that road is a tough road, it's not passable in some conditions. If you've driven it and you know that, that doesn't disqualify you. It just, you have a point of reference to weigh that evidence. On the other hand, if you're gonna go drive it yourself and do your own investigation, that's a different thing. That's not in the hearing, that's not part of the record, and that is, well, it's not okay, not in a quasi-judicial context. I know you're pulling the microphone.
Oh, I was just gonna say, I mean, and to that point, if you drive a road every day and you see a sign posted, that's one thing, but it's another thing to be like, I need to go investigate this on my own and go drive a road I wouldn't normally drive to collect information that I wouldn't have had otherwise.
For the rest of the planning commission, if we can continue to ask Lance questions. Thank you, Lance, for this. But I do want to get that 5-minute break in before we start the regular session.
And I will be here when I can. I cannot be here every Tuesday that you meet, but I will be here when I can.
Please, it would be very helpful. We have been asking for the county attorney to join us in these conversations because almost every land use application we've come across some legal question that we can't necessarily answer, and would have been really good to have the previous. Now it's going to be good to have you here. So thank you. When you can.
You're welcome, and I'll just tell you, I never knew my predecessor. I hear he was a very likable person. I don't know that I would have agreed with him, so if he's giving you advice and you hear something different from me, people don't always agree. I know why I think what I think, and I'm happy to explain it.